course, in the UK, it seems like for years now, where the racing sort of disciplinary area has been dominated by the Jim Best stopping saga. Paul John, the jockey, Jim Best, the trainer, Matthew Lone, part of a panel that then got rid of. Then we had a new panel, a so-called independent panel, who would then decide that stopping horses was worthy of a 6-month ban. Hundreds of thousands of pounds spent. Was it all worthwhile? Well, let's speak to the BHA, who haven't spoken much about this case at all since Jim was banned for 6 months on the 12th of December. We can speak to Nick Russ, the Chief Executive of the BHA, right now. Good morning to you, Nick.
Good morning, Matt.
Lovely to have you on the show. Look, no one in their right mind is in any way going to hold you responsible for what most of us feel is a total shambles, Nick, but you are the head of the ship that appears to some of us to have been sinking over this case. Can I ask you, first of all, if when you became Chief Executive, someone had said to you, a panel will find a trainer guilty of stopping horses, of instructing a jockey to stop horses, they will be banned for 6 months and then they can come back training, and in the meantime their wife may apply for a licence, she may get a licence and she may train during that 6 months. Would you be slightly surprised by that scenario?
Well, you've laid it all out there, Matt, early on. I mean, the first thing I'd like to say is that this is obviously a very important case. Serious allegations.
No, but Nick, would you be surprised, just out of interest, just away from, we can get onto this case in a moment, but if I had said that's what will happen?
If you'd put it in that way, yes, I'd be a little surprised, and we can come back to that. But
okay. This
is a very important case. There are obviously serious allegations made by a vulnerable conditional jockey who came to us and alleged that the trainer in whose care his conditional licence was had instructed to him or coerced him into stopping 2 horses from running on their merits, Missile Man and Echo Bravo, back at the end of last year. As a governing body, we have many responsibilities, but the core, of course, is the integrity of our sport. Without integrity, we have no sport, obviously. And we have 2 jobs to do as the regulatory body in this regard. The first is to ensure that there's a fair quasi-judicial system in place, so the disciplinary panels and so on. And the second is making sure that we take all steps to put cases before those panels which may strike at the heart of the integrity of the sport. On the first part, on the fair judicial system, this is what we've delivered this time in this case and in many other cases. Christopher Quinlan QC undertook a review, which I initiated back in July because I wanted to assure the racing public and those particularly taking part in the sport that they could have confidence in our system. We committed to publishing that up front. We committed to publishing every word of that before we knew what he was going to say. And in that, he found that our system already was fair and legally robust. So that's the system in which the Jim Best case was first brought forward, and it's the system within which the case has now been resolved. And the BHA has done its job with that regard. With regard to prosecutions, we had to prosecute this. Some people said, well, gosh, you've had this setback of your own making in April where the appeal was upheld and a rehearing ordered. And we accepted it at the time and apologized for the error of judgment with regard to not disclosing Matthew Lone's involvement in other activities within the BHA. But we had no option. These were serious allegations, and we needed to put the case on. We put the case on despite a number of obstacles being put in the way between April and December. The case was put, and despite Mr. John, who was very brave, I think, in taking quite a lot of analysis of his own character, the panel believed him substantially over Jim Best, who they found in breach. They found had lied about a number of the points that he put forward, and they found that he had done something which they described as reprehensible and which strikes at the heart of our sport, and handed down a ban for 6 months.
Well, yeah, I mean, I understand all that, but 6 months, I mean, overnight, we have a comparison. I know every case is different. James McDonald in Australia backed his own horse to win, and it won. Jim Best has stopped 2 horses from winning, according to this panel, because they found him guilty of that offence. He has therefore cheated the betting public. Well, there's no cheating with James McDonald. He got 18 months. Jim Best got 6 months. Darren Egan, who got, was cheating, effectively stopping horses, he got 12 years. You've spent hundreds and thousands of pounds to get Jim Best banned for 6 months. There can be no congratulatory feeling about this at BHA. You effectively have failed. You've technically won a case, but failed to basically get any punishment at all.
Well, he's going to be banned from the sport for 6 months, and his.
It's hardly a deterrent, is it, Nick?
Look, I mean, speaking personally, we would have liked to have seen a tougher sentence coming down for this. That's true. We would have liked to have seen that. We've read very carefully what the panel has had to say, and we note their comments with regard to guidelines. Within the penalty guidelines, there was the scope to hand down a longer sentence. But look, we can't be held to account both ways. We've been asked to put in place an independent judiciary system. A panel is put in place that's of unquestionable independence, and it's made its decision. Taking into account the facts concerned, it is not our job to prosecute and to be the judges. Those two things have to be kept separately. What I would say, Matt, is that this gives me a mandate now to make sure that the toughest penalties can be put in place within our sport, and I don't expect any pushback from representatives of trainers, jockeys and horsemen with regard to the most serious cases, and we will be taking into account very seriously what this panel says and looking at our penalty structure as a result.
To an outsider looking in who doesn't know all the rules, and the rules are incredibly complicated on punishments, it's really hard to work out what any of them mean. No wonder the panel got confused. They'd have had to sit there for the rest of their life to work out what they could give. But to an outsider looking in, it seems strange that one panel could give a man 4 years, and then another panel says that the rules don't allow them to give him more than 6 months. How is it that the first panel found rules that allowed them to give him 4 years, but the second panel couldn't find that?
Well, the answer is that either panel could find what they found within the guidelines that are given, but the cases, effectively, the first panel is null and void. Their reasons were challenged in the first panel. They are separate decisions, and the second panel has to hear the case afresh, has to hear what's put in front of it, and has to make sure that it takes into account all the relevant circumstances. So it's making a decision independently. And at the end of the day, the penalties that are given are actually only guidelines. They're not constraints. So again, it was for the panel to read the guidelines, understand the rules, look at precedents, and make its decision. And it's come out with where it's come out. But look, Mr. Best hasn't just got a 6-month suspension. In the submissions made by his own QC on penalties, Jonathan Laidlaw put forward that he'd suffered quite a bit in the 8 months between the first hearing and the second one, in that the number of horses he was training had fallen from, I think they said 30 down to low teens. So,
come on, Nick, on that basis, you're not saying that that's the right penalty for the crime.
I'm not.
Of course you're not.
Saying that I'm not. I'm just saying that to be very clear.
If I do wrong and get a headache, then it's all right. Let me off.
I'm not saying that at all. I'm just saying that was argued, and it's quite clear that his reputation has suffered, as it should do, frankly, given the reprehensible acts that he's undertaken.
You are a highly intelligent individual who will have been well briefed for a conversation like this, Nick. But I need specific answers to some specific questions. Let's start with something which is simple: yes or no. Was there a deal with Paul John?
No, there can't be a deal because there
was a deal, Nick. The second panel said there was a deal.
No, they said a deal in inverted commas. And
hold on, what's a deal in inverted? There was a deal, wasn't there, Nick?
No. What I'd like to make very clear...
But wasn't there was an email from Graham McPherson laying out what the deal was?
No, there was an assurance given that the BHA's prosecution function would seek a particular outcome, given that he had come forward and blown the whistle. That cannot be binding with the panel. The panel has to make its own decision separately. We have no power to reach a deal about what may happen in front of our disciplinary panels. As it happens, and at the risk of going back to what you were just covering, Paul John received the same suspension as Jim Best did, so he did not get any favourable treatment here.
You're still denying. I mean, you've always denied this, but you're still denying there was a deal.
No, I'm not denying that there was an arrangement made where we said that if Mr. John came forward, that we would be prepared to argue for a particular outcome.
But that's a deal.
Well, if you want to characterise that as a deal, it's been
So there was a
characterised
deal.
very differently.
There was a deal. If the deal was this,
perfectly understandable.
Come on, Nick. There was a deal. But if John comes forward, you treat him leniently. That's a deal.
We cannot treat him leniently in front of the panel. The panel decides. All we can do.
But the panel knew he'd come forward on the basis that he would be treated more leniently. That was the deal.
All that we can do is assure him of what our stance would be when asked by the panel of our views of it. That was what the commitment that we gave to him.
Do you think in a 50-50 case, which this is just one man's word against another, that it's right that you were approaching someone and saying, whatever it was you said, but you just said the words, if you come forward, which might suggest anything. Do you think in a 50-50 case the BHA should do that to one of the parties?
I think it should, where we believe that there has been wrongdoing. We need to make sure that we can have a case that that will stand up, and the only way that you can have that in one case versus another, one word against another as you characterise it, is to make sure that people testify. And you can understand that in a situation where a jockey is vulnerable, feels that he's been instructed to do this, and was quite compelling to us with regard to that, you can understand that he may have some reservations about coming forward. And having come forward, we wished to provide him with some assurance that if he decided to give evidence, that we would not go for the maximum penalty against him. I think that's perfectly fair, and it's very normal in the eyes of the law. As it happened, the panel decided that, irrespective of this, the video evidence and substantial parts of what Paul John said, they fully believed and decided that Mr. Best was lying and his actions were reprehensible, and they have decided that he is in breach, something that he has chosen not to appeal against.
You see, Nick, it doesn't matter what people in racing think about Jim Best, whether it's positive or negative, but there is no doubt with this case a feeling a little bit like racing in inverted commas had with Kieran Fallon back in the day, that the BHA simply went after Jim Best, had decided this was a man they could probably get somehow. And the evidence slightly is in the case of this, because as far as we can tell from the case notes, the BHA had decided to go after Jim Best before even speaking to Paul John. Now, if I was building a case at anyone and I had one key witness, my idea might be just to speak to that key witness before I decided to go after the man I was going after. But the BHA went after Jim Best before they had even interviewed Paul John. Do you not feel the BHA should have done just a little bit more research?
No, we did plenty of research, Matt. And
well, you didn't speak to Paul John before you decided to get Jim Best.
In the circumstances that we just described, with a young jockey coming forward, he did it through legal representation. He was quite keen to ensure that that his outcome would be considered, as you would expect, and his coming forward came through legal representatives. We did things properly. We do things properly, and reaching a discussion with Mr. John with regard to what he can expect, with regard to what we might say about our views on the penalties he should face for his wrongdoing, is a perfectly reasonable approach for him to take and for us to respond to.
But we kind of know, and again, you know, as I say, none of this matters what people might have opinions of Jim Best. But the key to this is that the evidence effectively was so small. It was just Paul John's words against Jim Best. And, you know, it's hard to believe that in any court other than the BHA courtroom, that this would stand up. It would almost be thrown out. There was just no evidence. There was just one man saying, this guy's a wrong 'un, and then a panel that eventually decided that that man was more believable than Jim Best. I think,
Matt, if I can interrupt you on that, I think in terms of whistleblowing cases anywhere, in sport, in life and so on, it is extremely difficult to have people coming forward, because in the very nature of whistleblowing cases, there are particularly difficult circumstances. When people do come forward, we should listen to them. And to sort of say in any court of the land this would not happen, I don't accept that. I don't think that's true. And we had 3 people sitting on a panel here on the rehearing, 2 of which are eminent or were eminent people within the judiciary who are highly experienced in this. If you look at the way that they conducted the case, the way in which they've written their reasons, the way in which they've considered things, you can see that they've taken great care and attention. And at the end of the day, they've been persuaded that Mr. Best has undertaken significant wrongdoing, reprehensible actions. I reject the fact that we did not bring a good case.
We're up against the clock a little bit. I've got 2 more key questions that I want to ask you, Nick, and you'll be relieved to know we've only got about 3 minutes left. So the first one is, on the basis that you've just suggested whistleblowing is key for any sport, and clearly in this kind of circumstance, if you had a reliable witness, it would be key. Do you think that what's happened in the case of Paul John has helped whistleblowers come forward in the future? Would you think that if there is a whistleblower out there right now, they would be thinking, I can't wait to go to the BHA and tell them what's going on. It's going to be so simple. I'm going to come out of it so well.
Well, we have people coming forward every day, and it's the basis upon which we frame a lot of our cases and go to the point where we can take them forward as cases for prosecution within our system. I would say that, if you read what Paul John said the other day in his article in the Times, he feels vindicated for coming forward. He felt that it was very important to him that his version of events was substantially believed, which the panel did, despite, a character assassination on him by Jim Best's team. And so, he seems fairly satisfied with the outcome with his comments.
Okay. Sorry, Nick, I just got to interrupt. We kind of get that. And I want to just ask you, Matthew Lone, who sat on the first panel, how did the BHA let that happen when they were told he should not have been there because effectively he was your friend?
We apologise for the Matthew Lone incident. He was given work on a discrete matter in 2013 onwards. You say that we were told. The PJA did write to us, and the full details with regard to what happened on Lone are going to be published later today. I made a commitment to do that once the Best case was out of the way. It will be there for all to see in chronological order. We made an error of judgment. He was advising on a medical matter to do with Cheltenham Racecourse. He's a qualified doctor. We were looking for a little bit of quick advice with regard to a reporting of an incident at Cheltenham to the General Medical Council. And knowing that he had a medical background, we asked him for a little bit of advice. That then went on to being a more formal involvement in a report on the issue, involving 2 of our directors leading up that report. And frankly, we didn't ask enough questions of ourselves with regard to disclosing.
So the BHA accepts that that was a fairly catastrophic mistake? No,
we accept that it was an error of judgment.
So it was a mistake?
It is a mistake, yes. We accept it was a mistake. We've apologised for it. My job as the Chief Executive is to make sure that not only do we learn from that, but we put things right. We've got 9 cases that were potentially affected from that. We took it upon ourselves to deal with those. There were 2 still in play. One was the Best case, one was the Gilligan case. Both of those are now completed. Mr. Best is not appealing, and we understand from Mr. Gilligan, that he is not intending to appeal. So those 2 are dealt with, and 4 of the other 7, which were out of time, have already been disposed of, with 3 to come, which we expect to clear in the first quarter of next year. So I'm doing what I can to make sure that not only is our quasi-judicial system reasonable and fair, but that we clear up the backlog of cases resulting from the Lone issue.
And final question, Nick, and it merely needs a yes or no answer. Okay. In the future, if a trainer goes before a panel, an independent panel, and they find him guilty of the heinous crime, the worst crime in racing, of stopping horse, of instructing his jockey to stop a horse, yes or no, would the BHA expect that punishment to be more the same as 6 months?
Well, I'll give you the yes or no, but first of all, every case is different, so it's going to depend on the circumstances.
Been found guilty of stopping a horse, Nick. More or the same?
What I will repeat is that The guidelines are there to give substantially more, and as a result of what this panel found, we will be looking pretty hard at the penalties in such circumstances because we wish to ensure the strongest of deterrents is in place.
My advice is don't work pretty hard, Nick. Work extra hard, because for all of us out here, punishments simply do not fit the crime. Thanks for coming on.
Thank you.
Nick Russ, the Chief Executive of the British Horse Racing Authority, as we go for a break.